I wonder if any one of you have read this book of fairy tales. The author's name is, you might have heard of him, this famous guy, Dr. Ben Bernanke. Yeah. The title of the book is A Course in Microeconomics, but it's a book of fairy tales. So I just wanted to point out something in the dialogue to you first. Most of you read it by now. There's quite a lot of subtext going on. Obviously, there's two characters. One of them is Frank. The other one, I can tell you, is a lady by the name of Olivia. And there is that line which says, quite clearly, you speak as if the two are the same, the wrong and the criminal. And the important thing to take from that is, well, he obviously believes the wrong isn't the criminal thing. They're not the same. But of more significance is what Olivia says. The thing they're trying to pin on you. I mean, you always think justice is a discovery process for those who are not actually accused of prosecuting the case. And it looks like, and the government should be in the business of a discovery process. It sounds like the government is in the process of a witch hunt. And that's a dangerous trend that we'll come back to towards the end of the talk. What I want to do also is give you a couple of concepts which you can keep at the back of your mind, and then we'll bring them to the forefront of your mind every now and then. The first concept is what Rand introduced, Ayn Rand. She called it a floating abstraction. And in objectivist epistemology, all knowledge comes from concepts and abstractions. But at the end of the day, when you drill down into those abstractions, you can always link it to reality. There's a unit of reality. So furniture is an abstraction, it's complex. You drill it down, there's tables and chairs, and there's one table, one chair. So I can always come back down just one step in that case, but maybe 50 steps in something that is quantum physics, and link it to reality. Let me give you an example of a floating abstraction. I've never met or seen any politician in the entire world who can define family values, and yet they use it all the time, family values. Or another concept is, which philosopher David Kelly uses to illustrate this, is the environment. Now, the environment of the Siberian tiger is different from the environment of a hibiscus flower in Brisbane and your environment. But as if the environment is a sort of a code word that you should be all for. And that is a floating abstraction. There's another concept which I coined the term, which is, I'm not allowed to use it here, so I'll say it's intellectual self-pleasuring. But otherwise the word starts with M for Melbourne, and I'm not allowed to use Melbourne. And one of the things that happens in standard microeconomics is, and this is why I call it the book of fairy tales, is they build these castles, the castles of perfect competition, which have innumerable buyers and innumerable sellers. Technology is freely transferable at zero cost, zero entry and zero exit barriers. Labor is 100% mobile, just like that, just like in a matrix. One day you're working as an engineer in Siemens, boom, and suddenly you're a chef in a hotel. Boom, now you're a student. So that's the kind of world they build. Once you have bad assumptions, though, it doesn't matter how strict your logic is, because it's like what the computer geeks call GIGO, garbage in, garbage out. So the inferences are absolute garbage, because the assumptions are garbage. Never mind, the middle part could be very logical. There could be all sorts of mathematical equations in there intended to scare you. Question the assumptions. But the sad truth is, there are laws all over the world, in fact, that have more than 100-year history in the United States, that are based on this intellectual self-pleasuring. otherwise called as microeconomics. And there are Nobel laureates, Robert Stigler, Paul Krugman, Robert Samuelson, that not only advocated, but I get this sort of image that they're kind of going there, oh, this perfect competition is so good. Wow, it's not getting this intellectual orgasm. Oh, if we could have perfect technology, we would have great Pareto efficiency as well. But based on those laws, a lot of innocent people have been criminalized. So it is a very grave outcome, and that's something we're going to quickly talk about. The other thing I want you to keep in mind is the culture. There's a professor called Dr. Jack Lule, L-U-L-E, and he wrote a book called News and Narratives, News and Mythic Narratives, or Daily News, Eternal Stories. And in that, he basically claims that what mainstream journalists do, and they ought to do, is to serve as a moral guardian of society. I didn't get the memo. Did you? I didn't get anything that said the New York Times or the Sydney Morning Herald or the ABC shall be your moral guardian. Sign here. But that's actually what happens in news. After 9/11, a sort of a funeral ritual played out in American journalism. Newsweek had a photograph of bin Laden that was put against red light. This is sort of the implication that he was the devil. Time magazine had a hymn on its cover. There were stories of redemption, courage, and redemption and courage and patriotism that played out like a story in American journalism. So when there is a big event, subconsciously, the journalists played out like as an illustrative story, as a mythic story, which tells you these are the things you shouldn't do, these are the things you should do. This is bad, this is good. And so they glorify heroes. Now, the first example I've got there is Jessica Lynch. Jessica Lynch was a 19-year-old who was in a Humvee that accidentally detoured into Iraqi-controlled territory. She was in the US Army. She fell unconscious, and there was a battle, and in the battle, a cook who was blonde shot a few people until he got shot. Something happened in the translation, and Washington Post said Jessica Lynch was the hero. The whole world said she was a hero, even after the facts were known. The doctor said she had no bullet wounds. And the news media just carried on and on like, oh, she fought like a lion. She shows the capacity for her sex's capacity for steely heroism. So there was that kind of women in combat thing. And this went on even after Washington Post admitted their mistake, even after Jessica Lynch admitted she'd never fired a shot. And it went on for 6 years. She got all sorts of valor awards because they just needed a hero, and they painted her, oh, she was the daughter of a truck driver, raised in a tin-roofed house. There was all that sort of rags to riches story. So this narrative was made up by the media, and by all the media, including the Daily Telegraph here. And they repeated the mistake in Fort Hood in Texas in 2009. Munley, Sergeant Munley, Kimberly Munley, was shot. One of the ironic things that happens in army bases is that people who are supposed to protect us are not allowed to carry guns. So when one of them went rogue, he managed to kill about 6 or 7 people, injure another 6 or 7. And these are the people, they are the soldiers, they're carrying great weapons, they are trained to shoot. But they had to wait till the police came in. Munley was the lady who got shot, fell down, and I'm not being sexist about it, I just want the truth from the media. The other policeman was a man who shot the assailant, a major, somebody or the other, and Munley then was just proclaimed as a hero, for a while anyway. So one of the things the media does is also paint an archetype of a negative. When Mike Tyson was accused of a rape, Time magazine and Newsweek altered his features to flatten his nose and make him look more beastly. I mean, it was outright racist. to give you an example of how you should not be. And it continues to this day. When anyone is too far outside the realm of society, that person would be painted as the face of evil, just like it goes on today. Why hasn't anyone from Wall Street been arrested yet? So I'll show you an example. This is New York Times in 1990, a landmark case. The gentleman's name, Michael Milken. Some of you might know him. He pioneered what they call the use of junk bonds, but what he actually did was use high-yield bonds with equity kickers, and his major contribution was to have a great network of financiers who were prepared to take a risk and take some companies to great heights that those companies were small companies that wouldn't have been. I mean, it was the birth of Barnes & Noble, MCI, Macau Cellular became AT&T. There's something like 3,000 companies that came into existence. So the irony is he actually reduced the entry barrier. You didn't have to have capital. And there was a lot of employment because of him. But here's the story on the day of his indictment. Isn't he the criminal? Tears began to well in his eyes. He put his right index finger under his nose. Why is this journalism? Oh, I'm truly sorry. And he's crying. His face was reddening. Is this a novel or is this New York Times? It's New York Times. I thank the court. And I'll come back to this case later, but essentially it was a plea bargain which was intended to victimize him. He was the face of Wall Street evil. Something had to be done. And it's going to happen again because President Obama has formed a financial task force. It's called Financial Fraud Task Force. And the news at the moment, I'm sure you don't read New York Times or Washington Post, says, why hasn't anyone from Wall Street gone to jail yet? So it's like this war is going on. Is that person guilty? It doesn't matter. Let's have some people from Wall Street go to jail. By the way, I'm not a fan of Wall Street. I understand that the banking cartel and the Fed Reserve and the banks are subsidized, but that doesn't mean everything in Wall Street, including hedge funds and private equity and every individual, is bad. But that's the mythic narrative that is playing out in the news. And it's of an enormous advantage to the state. So the way we should actually look at corporate law is, and I'm just going to use a few examples because we don't have, enormous amount of time. First question is it even morally wrong? Secondly, if it is wrong, should it be criminalized? Is that the answer? The first thing we'll look at is insider trading because that ends up locking up a lot of people. And sometimes, for quite a few times, people who didn't know they were insider trading. I've just taken a random graph here of a share price. Let's say it was $10 of a company, and there was some news an insiders had that was negative. So as a result of the news, when it was known, the price fell to $5. If there was a trading halt because there was inside news, it would fall like the red line suddenly. If the insiders were allowed to trade, it'll probably fall very fast. Right? So there is an argument that there's corporate efficiency going on. But there's also a corresponding argument that it is unfair to some people. Because it's unfair to people who would have been disbarred from trading if there was a trading halt, went and bought the share for $6 or $9, and they would have been disbarred from buying, and they would have got it for $5. So they're the losers. And the accidental winners are those who just happen to sell anyway without knowing the inside news. And if you feel that way, there's a number of, so I'll skip the material non-public, I'll come back to that. There's a number of solutions that are possible. And I take the example of private equity where I worked for a significant period of time. In any private equity sale, it is extremely common for the buyer to ask the seller to give many warranties, but one of which would be that you've told me everything that you think is material and that you know, and you have not, firstly, you haven't lied, you haven't told me anything that's outright false, but you haven't withheld it that you have been forthcoming despite the fact that I might have forgotten to ask you a question. It's very, very common. And so if you wanted to have that sort of a regime in the public market, it'd be quite difficult, of course, but it's nevertheless possible. One solution, which doesn't take care of the fairness problem, but it takes care of the efficiency issue, is to say, well, let the insider trading happen. Well, UCLA professor Stephen Bainbridge says, at the turn of the 19th century, the Supreme Court in the US regarded insider trading as a normal emolument of corporate office. It was just like a perk. So we could have that. So, you know, you and I could start a company where we say, yeah, we're okay with that. You know, our managers can trade. But then these people here on this table might be the investors. They don't like it. We're company A, we're manufacturing widgets. They don't like it, so there's another company B, they say they'll remain private, or B, they will impose a contractual requirement on their managers to not trade in an insider way, or have frequent trading halts, which is something we used to do in our practice. And we were told by a lawyer that the ASX does not look upon kindly when you have frequent trading halts. Well, it's a difficult situation because you have to have continuous disclosure. That means every time you're working, doing business, you've got to keep disclosing. You have to judge whether it's material or not, which is very hard because a judge will determine what is material information to share price with the benefit of hindsight. So when in doubt, disclose. So you spend half your day doing your job, half your day disclosing. And it's not a great outcome for small companies. For big companies, they have specialist departments that look after that. So you could certainly have a private solution in which privately owned stock exchanges impose that rule and decide to monitor it. So Sydney Stock Exchange might say, we won't allow insider trading, we will police it. And some investors may be comfortable with that. Brisbane Stock Exchange might say, oh, what the hell, we're Queenslanders. Let them trade. And that might be a good outcome for investors. So let the free market decide and let the state just get out of this whole insider trading business, which is kind of it's like a two-pronged solution. I personally believe it is kind of very efficient to let insiders trade, but on the other hand, I understand the unfairness argument, and I'm personally a fan of there being more and more private equity. But the narrative is here that if you are like a stock analyst and you investigate and you analyze and you get hold of information through effort, that belongs to society. That's the narrative that's carried in the economics textbooks. And we be very careful of that because I remember Jeffrey Tucker in the morning said, oh, the first page on the first lecture of economics tells you what economics is about, and you know, something scarce, resources, so many wants and all that. Now, if you notice in Bernanke's book on the first page, it says, economics is the study of how individuals make economic decisions. That sounds pretty all right, doesn't it? By halfway through the book, he's saying, economics is the study of how society allocates its resources. I missed something. It's a sleight of hand here. All of a sudden, the resources belong to the whole of society. By the end of the book, when you come to the chapter on perfect competition, because after that you won't read it, he says, what ought, suddenly the ought word comes in, ought to be the policy so that society allocates its resources efficiently. That's communism. It's not microeconomics. Oh, most of it is a fairy tale anyway. It should be Grimm's. So one of the things the state does, it bases these laws on a kind of foundation that only exists in some textbooks in microeconomics, and which is a foundation of intellectual self-pleasure. And that's what's kind of dangerous. But I don't know if all of them recognize that. Some of them that do think they've got a great weapon here for compliance, because they can just, when everybody is criminalized, what it means is that those who dissent from the status quo can simply be brought in for questioning, made to do a plea bargain, fined, banned, put into prison, all sorts of things. I'm going to go through this fairly quickly because it's quite easy. In the market for corporate control, in a free market, corporations should be free to decide whom to merge with and what procedures to follow. But the government has decided that we all are dumb idiots and we need help. So we should get a memorandum called a prospectus or a product disclosure statement that tells you all the risks. And God forbid if you're a director of a company who forgot to tell them one risk and that came to bear, because they'll sue you, and even in Australia you can be criminally liable, and your estate is nevertheless always at the mercy of criminally liable for insolvent trading, but even for improper disclosure or failure to disclose, it's a contravention of corporations law. So there is a solution around it which we used to work around, which is to make the offering memorandum extremely thick and put in every conceivable risk there can be. If foreign exchange rates, the US dollar might become 20 cents to the Australian dollar one day and then you lose all your money. Well, if you're buying shares in Sydney Airport, there could be a nuclear explosion and you could lose all your money. And of course you can lose your life, but we're not bothered about that. So you can't list every risk there is. And then there is a minimum period. And the problem with the minimum, I think it's a 21 working day period, is that then companies say, I got to be able to approach the market quickly when I need money. So here comes Bond Street, the equivalent of Wall Street in Australia, and says, well, why don't we do a private placement? And why don't we do it at a dilutionary rate, meaning if the share price is $5, in a managed investment scheme, they can go just to the big fund managers and offer shares for $4.50. So you and me, the retail shareholders, are going, oh, hang on a minute, I'm getting diluted here. It should be a renunciable rights issue. Oh, but that can't be, because if they were to approach you, they should have a prospectus. And it takes 2 months to prepare, because so many lawyers have to go over it and so many staff have to go over it. And it should be out there for a minimum, I forget, it's 21 or 26 days, 25 days. So there is no time, they need the money quickly. So the end result of this protection racket that is intended to protect you ends up working against you. You as in, I'm assuming we are all retail investors rather than part of some Bond Street elite. Because if you're the elite, you get your private placement. And again, the rules are based on a narrative that is a protection narrative. One thing I forgot to mention earlier is if you want to look at the narratives more about how journalism spins a false narrative, there's a great book by Dr. W. Joseph Campbell. He's professor of journalism at American University in Washington. The name of the university is American University. And the title of the book is 10 of the Greatest Misreported Stories in American Journalism. Outright falsehood. I mean, Jessica Lynch is from his book. The other story that I picked up, Mighty Mouse, is something I did some subsequent research on that, and I picked up 3-4 more stories like that. Back in the Australian context, so we have this thing called competition law, which is based on this crazy, fuzzy concept of perfect competition. In the world that just never exists. I mean, take one of the examples of perfect competition, one of the illustrations. No entry and exit barriers. That means if you need $1 billion to start an automobile plant of any size, well, that's a big entry barrier. You need capital. But think about what that capital does for a minute. What that capital does, it allows you to have economies of scale. Because if you're manufacturing 5 cars a month in some backyard and trying to sell them, irrespective of government regulations, safety and all that, it's practically impossible for you to achieve the kind of cost efficiency that a big plant and an assembly line and specialized labor and expertise does. That takes $1 billion. It works to the benefit of the consumer because that brings the cost down, because you are going to sell the cars either at an extreme loss and go out of business, or you're going to be pricing them 10 times the cost of some assembly line in Korea or China or even the United States. So a high capital barrier works to the benefit of consumers. But it's all right, it's all intellectual self-pleasuring between Stigler and Samuelson, and they come up with these inferences. One of the inferences that in perfect competition, the price should equal marginal cost. And that's completely ridiculous because you have to cover your fixed cost, otherwise you're going to go out of business. I mean, the marginal cost for an airline, which is kind of 3/4 full, is practically almost zero. So should all airline tickets be priced at zero? That's going to drive the airline out of business. And the way they defend that, they say, oh, but marginal cost keeps increasing, and therefore the average cost is covered, some of the fixed cost is covered. Well, not in the majority of industries, marginal cost doesn't continuously increase. All of these assumptions are made in some sort of a fairy tale heaven that it's a complete floating abstraction that has no basis at all in reality. Not even as much as, say, Star Wars or Harry Potter. Because at least in those tales, we have allegories to human nature and human emotion. We can derive an inference about guilt and behavior in those worlds and bring it back to Earth. And so their inference is a monopolist will charge until marginal revenue equals marginal cost, therefore produce less, so monopoly is bad. And they bring the inference into the real world, and we have the Sherman Act of 1890, we have the Clayton Act, we have the Federal Trade Commission in the United States, we have Trade Practices Act, which now became CCA, the Consumer and Competition Code, we have the ACCC in Australia, and even in places like China and India, there's competition law, based on nothing but a complete, pure fantasy. So in Australia, they're also part of that competition law is, oh, you should not price your product too low because that's predatory pricing. So let's say Mr. Austin Erickson and Mr. Ben O'Neill are in competition with each other. We hate them, we want to criminalize them. So Mr. Erickson is pricing his product much lower than Mr. O'Neill. He's indulging in predatory pricing, so he's a criminal. Mr. O'Neill is probably a monopolist. So they get worried, so they say, let's keep our price the same. Oh, but they are colluding, the price is the same. So everybody can be criminalized. And that's a great weapon when you have that. And in addition to that, oh, you can't say, if you buy my product, you got to buy this other product, which is what Google got into trouble with. You can't say, if you buy my product, you should also buy Mr. Samuel Marx's product, even though there's no law prohibiting the other person who's the buyer from saying, well, no, get lost, I won't deal with you. The true monopoly is the government monopoly, where the government owns everything and disbars other people from entering the field, such as probably NVN is going to turn out to be in broadband, or where there are licensing laws like in cabs in New York and even in Sydney cabs, where you need a license from the government rather than having the freedom to start your own cab, and that raises the cost. Those are monopolies or quasi-monopolies. Alcoa wasn't a monopoly, it was sued as a monopoly. The other power they have is to say, if there is a merger or an acquisition that results in what they call SLC, substantial lessening of competition, and the ideal is, that perfect competition model, then they can prohibit that merger from happening. But the ACCC in Australia is a queer beast. This was about 10 years ago. I was involved in trying to do a merger where there were American utilities, CMS and NRG with Macquarie Bank bought a power station, Loy Yang, a coal mine and power station from the Victorian government for nearly $5 billion. That's B for Brisbane billion. They overpaid. A few years later, we went and offered them $3.5 billion, wiping out their equity. We, as in, there was a consortium of people called the Great Energy Alliance, which involved AGL, Tokyo Electric, and a bunch of investors, superannuation funds, so American equivalent being 401k. And the ACCC said, we had numerous meetings with them, and they used to just sit there and, well, you go ahead and do your merger, and then we'll tell you afterwards, or your acquisition, whether it is afoul of the act or not. I mean, that just doesn't make sense. It's not practical. I mean, by the time you finish an acquisition of this nature, you've paid away millions of dollars in legal fees, millions of dollars in investment banking fees. It would cost you $25 million to undo all of that. So there was a landmark case in Australia which was called like a declaratory case. Unfortunately, we won. The ACCC was defeated because the Chief Justice, who is currently the Chief Justice of Australia, Robert French, was presiding over that case. But that's how bad the sort of competition thing gets here, and it's worse everywhere else. We've covered that. The news narrative at the moment is capitalism is evil, a floating abstraction of perfect competition. No one questions it. The most excellent companies are always punished under this antitrust law, although everybody could be. You see it's like a who's who of American industry when you see who the antitrust division has gone after. Now, we saw that narrative with Michael Milken, and I'm just going to rush through about what happened there, because it's quite instructive. The news narrative was, Wall Street is evil, let's get somebody. He was a pioneer who actually helped industry in the small guys get up to the top, and it's a fantastic list of companies that he helped grow, including sort of Barnes & Noble, MCI, AT&T. But Ivan Boesky was a criminal in a sort of a real sense of the word. He indulged apparently in fraud, and I got this from a book called 3 Felonies a Day. It's written by a gentleman named Harry Silverglate, not Gate, Glate, so Glate, and the foreword is by Alan Dershowitz. He became famous when he defended O.J. Simpson. And Dershowitz is known for his liberal, as in not classical liberal, American liberal, left views. And despite that, he says Milken was victimized through a plea bargaining process. So what you had is Ivan Boesky being told, you're going to get 20 years, but if you give evidence against Michael, 3 years. Someone else got immunity. Ultimately, there were 98 charges in the indictment, including racketeering, fraud, insider trading. Then the FBI began to question his 92-year-old grandfather. They indicted his younger brother who worked in the same firm, Drexel Burnham Lambert. And he's a guy who loved his family, and he sort of said, okay, I'll take the plea bargain. The plea bargain was, you say you're guilty of these 5 technical offenses, and we'll drop all the other charges. And they did that, and those technical offenses, some of them were ridiculous. It's like not filling a form in time, which before Milken and after Milken has never been regarded as a crime. One of them involved it's a practice called stock parking, which I won't go into the details of. But on the other side of the trade, there was a gentleman by the name of David Solomon. He was a fund manager who got immunity. And Milken was made to give evidence against a colleague called Alan Rosenthal. Now, Milken and Rosenthal did this thing together, the trade. Milken is guilty. Alan Rosenthal had no immunity. He's sent to court. A different judge says, but this is not a crime. And Alan Dershowitz, who was the lead lawyer in that legal team, as well as Harry Silverglate, had concluded the same thing, that Milken pleaded guilty to non-crimes because he wanted his plea agreement to be accepted. Because one of the things they were threatening him with was, because of the nature of the United States, the federation-style nature, there are many states rather than just one state that was going after him. So the chances of getting clear everywhere was getting lower, as well as it could be harassed for his whole life. So he thought, okay, I'll pay a $600 million fine and I'll get away with it, or go to jail for 6 months. But there was media pressure on the judge. You saw the New York Times article. So she was appointing a recent appointee of President Reagan. The judge, despite all their brilliance, didn't understand complex finance. They took in the narrative, Wall Street is evil. She sent him in for 10 years. Then when Rosenthal was freed, she discovered her error and then let him free. He had served less than a year. But the lesson was learned by everybody on Wall Street. that, yeah, be careful. Now, this is a funny kind of slide. It's a gloating slide in the New York Law Journal that comes from the partners of a law firm. The partners of a law firm shouldn't be gloating. 2012 highlights. You don't have to read all of that because I'm going to show you where it comes from. This is from the Antitrust Division. Aren't we great? We're getting more and more revenue for the government, over $1 billion in fines. And with the current cases on the LIBOR and other things, they're going to get even more. But the scariest one is the last one. 71% conviction rate. What happened to justice as a form of discovery? We just want to convict these guys. Aren't we great? The guy who went after Michael Milken, who was the Attorney General at the time, Rudy Giuliani, who became a presidential candidate in 2008. Let's get them. And that's why it's all based on this enormous fantasy, intellectual self-pleasuring of some basically Marxist economists, Marxist ideology. But the other thing is, it gives them that excuse when the financial failure happens, let's blame Wall Street. Why hasn't someone from Wall Street gone to jail yet? Let's get them. On the day, I just want to add one more thing, on the day Milken was indicted, it was a 110-page indictment. On page number 2, the Antitrust Division said, how is that? Well, let's say it's relevant. In 1983, Milken's salary, including bonuses, was $43 million. Wow, that's good. I mean, in current terms, it's 4 times that. Then it said in 1987, his compensation was $550 million. Today's terms, $2 billion, all contractually valid. The entire media concluded by the end of page 2, without reading the charges, without reading the evidence, forget the fact that they dropped the case, he must be guilty. Who makes $2 billion? He must be guilty. But I'm sure if I took a survey in this audience, you wouldn't presume that someone who's rich is guilty. Yeah. We've already spoken on Apple and Amazon. Amazon has been sued for pricing its products too low. And for the same products, Apple was sued for pricing the books too high. Isn't it nice that Amazon is pricing books low so that there would be a higher literacy rate? But the irony is lost on the government. That's all I had. I'd like to remind you that Austin has maybe some forms of a political organization called Liberty, LDP, Libertarian, Liberal and Democratic Party, that New South Wales desperately needs some more registration. So have a think about it. Go to ldp.org. The other thing is, this is the novel that I spoke about in the beginning. I've got some copies there that normally takes $25 to ship it, but for me as seminar participants, I've got it for $10 if you want to come and see me at lunchtime. That's all.